Now at 6, the future of former Columbus police officer Adam Coy, convicted of murder, is up in the air. That's because defense attorneys tonight are arguing for a new trial. Thank you for joining us tonight at 6. I'm Yolanda Harris. Coy was scheduled to be sentenced Monday, but that hearing is now postponed. Earlier this month, a jury found Coy guilty of murder, reckless homicide, and felonious assault for killing Andre Hill in 2020. 10 TV's Lacey Crisp was in court every day of that trial, and tonight she joins us live from the Franklin County Courthouse to explain why the delay. Lacey?
Well, Coy's attorneys argue the state hid information from them that was vital to the case. They have filed a motion asking for a new trial and for sentencing to be delayed.
The defense is claiming that there's a self-defense expert who said it was a good shoot and that the prosecutor didn't provide that information to the defense. If that's true, there probably does have to be a new trial.
In the motion, defense attorneys argue the prosecutor reached out to use of force expert Jamie Borden, who also testified in the murder trial against former Columbus Police Vice Officer Andrew Mitchell. The filing says Borden told prosecutors he believed Coy thought there was a deadly threat and was justified in his use of force. Prosecutors allegedly never made defense attorneys aware of this potential witness. Mark Weaver is an attorney and has served as a prosecutor. He's not affiliated with this case.
There's a U.S. Supreme Court case called Brady versus Maryland that requires prosecutors to tell defense lawyers if there's exculpatory evidence. What that means is evidence that maybe the defendant didn't commit the crime, or maybe one of the elements is missing. You have to give it over.
In the filing, defense attorneys wrote, when Mr. Borden made clear that unless he was presented with additional information that proved otherwise, it was his expert opinion that Adam Coy's actions were consistent with perceiving deadly threat, the state engaged in retail therapy to shop for an opinion favorable to that of the state's position. The state then purchased $13,000 man, Seth Stoughton.
The sentencing was scheduled for Monday and it's been postponed. Any idea why that may have happened?
Someone who's found guilty by a jury is not convicted until the judge orders the sentence. This is because there needs to be time for post-trial motions where the judge can consider whether the trial was done properly. The judge does have the ability to set aside the verdict and order a new trial. That could be what's happening here.
Now it'll be up to the presiding judge, Stephen McIntosh, to decide if he will proceed with the sentencing or order a new trial.
Judge McIntosh is a pretty good judge. I know him. I know his reputation. He's smart. He wants to do the fair thing. The fact that he's moved back sentencing suggests that there's some serious consideration of the defense's position. So I would not be surprised if this violation of not turning over the self-defense expert would order a new trial.
Yeah, so I reached out to attorneys on both sides. Neither would comment today. It will likely be a couple of weeks before the judge makes his decision. Reporting live, Lacey Crisp, 10 TV News.